At this stage, I think it's important to remember that the Belize Island Holding is an interested party and not a defendant. Essentially, the allegation by the B.T.I.A is that the Department of the Environment and the N.C.L did not comply with a very discreet provision of the regulations, that there was a second publication that should have been given and that it didn't have in it some details. Our position to the court is that, first of all, when you read the regulations, it's not required. And secondly, we say to the court that there was a publication, a second publication, and no member of the public said that they wanted to make any comments, any criticisms, etc. You will recall that there was in fact a public consultation where approximately 500 people were present and they had a lot to say, and as a result of that, constructive criticisms were given and amendments were made. The N.C.L, which is the expert body, said that additional information was required. That additional information was supplied, and then they considered it and decided, one, that they would approve the EIA, and secondly, that there was no need for a public hearing thereafter. And so we're asking the court, first of all, to give respect to the decision of the N.C.L because they are the experts, and that a requirement now to publish a notice for a project that's 80% done would serve no useful purpose. So that in essence is the case for the client.
Okay, what are the claimants seeking in terms of release?
Again, that's interesting. They're saying they want a declaration. A declaration, as you know, is just a court saying something. It is not an order for you to do anything. And they want a declaration that the notice that was published in February 2014 did not have in it certain details. Like, it did not have the name of my client, even though it said Harvest Key. Now, they want a declaration that it was published, but it was not in 2 newspapers in 2 consecutive weeks. It was in one newspaper for about 10 days, and that therefore the decision was bad. Now, we have pointed out to the court that the way they have brought their claim, that cannot result because they have not challenge the environmental compliance plan, which is the operative document. It is in that context that we say this entire case is academic. This is a decision that is 15 months old that they are now seeking to say to the court was not done in strict compliance with the law. Life has moved on.